Evening, this is Thomas Leonard Ross KC. Since the plea was tendered by Peter Murrell last Monday, the 25th of May, I've received a great number of inquiries from media organisations regarding questions, legal questions which arise from the case. There also has been a number of considerable inaccuracies on the media, principally the Scottish Daily Express, regarding the case and the procedure. And I thought it would be helpful to come on and just run through some of the legal issues which have been asked about in the hope of clarifying some of the points. Should make a declaration, I'm not a member of the SNP. I've never voted for the SNP, and in the 2014 referendum I voted to remain part of the United Kingdom. That doesn't affect my legal assessment of the issues at all. My intention is to be entirely fair to everybody involved, and only mention it because anytime I say anything about the Scottish Government, I generally come under attack from some people on Twitter. So you don't need to go and dig my profile or research my background. I support remaining in the United Kingdom. I also thank publicly the work of Joanna Cherry and Stuart Campbell at Wings Over Scotland. I've managed through those people to obtain quite a lot of information that I didn't have, and helped me to understand the background to what's going on better than perhaps I did just by looking at the mainstream media. So I quite rattle through the timeline just to put what I'm about to say in context. In 2017, the Scottish National Party launched a campaign to raise money to support a claim for a second independence referendum. In 2017 it said that they raised £482,000. In 2019 they raised another £185,000 approximately. So they had just under £667,000 for this referendum campaign by 2019. But by October of 2020 there was only £97,000 approximately in the party's bank account. And unsurprisingly, members started asking questions as to where the money had gone. In March 2021, the leader of the party, Nicola Sturgeon, did a video which I'll mention later, where she claimed that the party had never been in a stronger financial position than it is right now. She said that there were no reasons to be concerned about the party's finances, and she warned that members should be very careful about suggestions that there are problems with the party's finances. But the same month, March 2021, Sean Clarkin made a formal complaint to the police in relation to what he thought were missing funds. And in July of 2021, I think the 12th of July 2021, Operation Branchform was publicly launched by the Police Service of Scotland. And at that time, they said that the investigation was in relation to allegations that funds raised for a potential second independence referendum had essentially disappeared. So there's been a bit of talk of this over the last couple of days, that the case became about Peter Murrell using his influence over SNP accounts to purchase items for himself. But actually the inquiry set off looking at something quite different. Wednesday the 5th of April 2023, there was a search of the home address of Peter Murrell and Nicola Sturgeon. I'll say something about that shortly. And then on the 5th of April 2023, same day, Peter Murrell was arrested. On the 18th of April 2023, Colin Beattie, the Treasurer, was arrested. and on the 11th of June 2023, the leader of the party, Nicola Sturgeon, was arrested. I'll say a little more about Nicola Sturgeon later too. In December of 2023, the Court of Session granted a restraint order against Peter Murrell, and then on the 18th of April 2024, Peter Murrell was charged. The police reported that on the 5th of September 2024 they submitted the report to Crown Office, and then Peter Murrell made his first appearance in court, I think at Hamilton Sheriff Court, on the 20th of March 2025. Now, he having made his first appearance, various time limits became relevant. The 12-month time bar was the 20th of September 2026. The 11th month time bar was the 20th of August 2026. And the Crown required to serve papers by July of 2026. And I mention those dates really because it's obvious that Crown Office had time to wait until after the Scottish election. The election was in May of 2026. But they didn't have to serve any papers until July of 2026. So if the Lord Advocate or her staff were conspiring to avoid bringing the case up during the election campaign or even before the election, that it didn't really seem to make any sense to me that they would then serve an indictment for a hearing before the election and then making the hearing public and then fuel speculation by moving it. So I'll come back to that. So I'm guessing, I don't know when the indictment was served, but there has to be 28 days notice. So I suppose the indictment was served in Mr. Murrell about the 20th of January 2026, and it contained an allegation that he'd embezzled around £459,000 worth of SNP funds. The first date for the hearing was the 20th of February, but that was postponed by way of the Section 75A procedure until Monday the 25th of May 2026. Now, all the preliminary hearings take place in Glasgow, or almost all of them. And I think there might have been a wee slip here because Monday 25th of May 2026 happened to be a holiday in Glasgow. So quite late on, it was announced the hearing had been moved to Edinburgh. It probably shows the extent of the conspiracy theories. It didn't call in Glasgow because Glasgow was shut. It didn't stop people on social media claiming there was something suspicious about it being moved to Edinburgh. And then on the 25th of May, Mr. Murrell appeared before Lord Young and pleaded guilty to the embezzlement of £400,310.65 embezzled between August 2010 and October 2022. And then the narrative in the case was given on Tuesday of this week, the 2nd of June, and he is due to be sentenced on the 23rd of June 2026. So that's the factual background against which the case took place. A couple of questions which have either been asked of me or have occurred to me. You remember I made reference to the search which had happened, and one of the themes that has come up in social media over the years is the fact that the police erected a blue tent outside the family home, and this was seen as in some way a tactic to make things worse for the Murrells. I never bought into it. And the Chief Constable of Police Scotland, Sir Ian Livingston, was asked about this in June 2023, and he said that the use of the blue tent was proportionate and necessary. Now, we were all having to guess what the police were looking for, but we now know because there was this extensive list provided by Crown Office listing all the items which had been bought on Amazon and the things which had been bought from other online retailers. And that's what they were looking for. You know, the police were looking for those things. And anybody can see that it's much more convenient to do that at the scene than to empty the house, put the entire contents of the house into a removal van and take them down to police headquarters. Now, if they had just laid out tables and inspected the items and tables in the garden, then that would have been a breach of privacy. So it seems to me that Ian Livingston was actually bang on when he said that using the blue tent so that the many officers could go out, could use the garden space to check the items against the lists with due regard to privacy of the householders, makes a lot of sense to me. More difficult question, I suppose. We know that Peter Murrell got legal aid. Why did he get legal aid? Well, especially when it was said this week that the restraint order suggested that he would be able to repay the money. I'll come to the restraint order, but basically what his lawyers were saying was that there's going to be enough money to repay the money that was embezzled, and people are entitled to ask, well, he embezzled around 400,000. If his assets are more than 400,000, why on earth is the taxpayer paying for his legal fees? I don't know the answer to that for certain, but I suspect at the time when he made the legal aid application, he didn't have any liquid assets. In other words, what he had been seized by the Crown and frozen by the Crown. So although notionally he had funds, he wasn't able to take money out of a bank account or make a bank transfer or use a credit card to a lawyer, which would have paid for his legal fees. That makes sense to me. I can understand why people are annoyed about it. What I must confess doesn't really make an awful lot of sense to me is if we assume that a confiscation order is made for something like 400,000. I can understand why people are saying, well, at that stage, why does he not pay back the cost of his lawyers? But there doesn't seem to be any provision in the legal aid regulations for that to be done. So I don't suppose we can blame him for it. We certainly can't blame his lawyers. The biggest conspiracy theory that was been put about was, why was the preliminary hearing continued again until after the election? Now, I know I could speak about this for 20 minutes and people who are not lawyers are not going to be convinced about it. I know that's the position. I know that it, on the face of it, looks suspicious. The first point is, I've already made it, the Crown could have waited until after the election before serving any papers or fixing any date. So it seems a strange way to go about it. But you only get 29 days notice. You know, the papers are served about a month before the hearing. And when it's a fight outside a pub or possession of a kilo of coke or something, 29 days is plenty for you to work out what the case is about. But when it's an investigation of 12 years of embezzlement involving hundreds, if not more than 1,000 transactions with access to bank accounts and credit cards and all that, 29 days isn't a lot. So it makes perfect sense to me that the lawyers would approach the Crown and say to them, look, 29 days isn't going to cut it, we're going to need a bit more time. Once it's been agreed that more time is needed, you're actually in the hands of the court, because you can't go and say, listen, we think we could be ready, we won't be ready on the 20th of February, but we might be ready on the 20th of March. You can say that, but the court will give you the first date that they've got, and you can imagine, you've heard of the backlogs, the court's pretty busy. So, probably the May date was the earliest date they could get. And so it doesn't seem to me there's anything suspicious about that. People might say, if people had known the extent of the criminality before the election, the SNP might have got less votes, less seats, less seats. They might have, but I'm absolutely certain there was a good reason for it to be continued. Maybe Mr. Murrell wanted it continued until after the election. I don't know. I've got absolutely no reason to imagine why any of the lawyers involved, who are all of the highest reputation, would get involved in something like that. As to the disposal, I think there's also been a bit of confusion about that. Now, I don't want to get too deeply involved in the disposal because we don't know what it is yet. The judge has the power to make a compensation order, not often seen in the High Court. But I mention it because a compensation order, as you might expect, is a clear order that the offender pays money to the victim. Pretty straightforward concept. A couple of drunks go by my house and throw a brick through my window. If we catch them and it costs £200 for me to get the window fixed, then the court orders them to pay compensation of £200. That comes to me when it's eventually paid, and I get compensated for my loss. But it's highly unlikely that that will happen. It's more likely to be a confiscation order. And the confiscation order looks at two things. It looks at the amount to which the offender has benefited, and it looks at the amount which is actually recoverable. And if he had, for example, free proceeds in a house, or pensions, or that kind of thing, or any of the property which has been embezzled, I suppose, theoretically. Let's leave that out the equation for the moment. So, supposing they had free proceeds on a house, and he had pensions which could be cashed in, money could be withdrawn, then the court might make an order for 400,000, and that's paid through his pension fund, his pension pot, and essentially that's an end of it. If he doesn't pay it, then the Crown can take steps to recover it. So if he won't sell the house so that he can pay it, then the Crown can take steps to have the house sold. But the biggest misunderstanding when this issue has been discussed is when it's a confiscation order, the money doesn't go to the victim, the money goes to the government, and my understanding is that it goes to the UK government, who keep, in general situations, keep most of it. Some of it in the past has come back to the Scottish Government under the Cashback for Communities scheme, and I suppose the Scottish Government could approach the UK Government in a case like this and request, they could request that it's the SNP's money essentially and they should get it back, but that would really be nothing to do with the judge or the Crown Office in Scotland. I would imagine that would be an intergovernmental agreement. Interesting questions have been asked regarding ownership of the stuff that was embezzled. You know, there's been speculation that the motorhome will be sold and the proceeds will be put towards the confiscation order. I'm not sure about that, because it's certainly arguable that the motorhome is not an asset that belongs to Mr. Murrell. It's an asset which belongs to the SNP, and the same thing can be said in relation to other items which are traceable through the Amazon purchases, etc. So it might be that it's just agreed that those items belong to the SNP and they're given to the SNP, who can then sell them or use them. You know, I don't know the answer to that for certain, but all of these things seem possible. An interesting thing in relation to imprisonment, I think he will be imprisoned. He's been remanded. That's a pretty sure sign. Quite difficult for me to say what sort of sentence he might get. But certainly, if it was not for the fact he was a high profile individual and the circumstances were as they are, it's probably somewhere round about the borderline between a short-term sentence and a long-term sentence. Now in Scotland, a short-term sentence is less than 4 years, so if we deal with that first, it's not a violent offence or a domestic offence. So under legislation, ironically, which the SNP introduced on the 12th of May 2026, if he was sentenced to less than 4 years, then he would serve 3/10 of that. But if it was a sentence of 4 years or more, then in all probability he would get out after 2 years on parole. But he doesn't have any right to parole. That's a application which he makes. So they could keep him in for 3.5 years on a 4-year sentence before being released. So on a sentence of less than 4 years, you would do, as I say, 3/10, so about 30%. On a sentence of 4 years and more, he would do somewhere between half of it, that's the minimum, so he'd have to do at least 2 years, and not more than 3.5. So, ironically, again, he's in an unusual position that while he was serving the sentence, the SNP, who are the people who suffered the loss through the embezzlement, could change the rules, which could have an effect upon when he's released, and not many people have been in that unusual situation. Now, it's now 20 minutes. I was going to say something about the situation relative to his ex-wife, but I've kind of run out of time, so I'll come back and do that another time. So thanks very much for listening. Again, I can't answer any case-related inquiries, but if there are any general inquiries arising from what I've said, put them in the comments, and I shall be happy to answer them.